All rise. Circuit Court Division CRD in Individual County in the state of Florida is now in session. The Honorable Russell Haley presiding. May God save the people of the state of Florida and this honorable court. There will be absolutely no talking or communicating. Please make sure cell phones are turned off. You may be seated.
Good morning, everybody, and welcome back. We are ready to begin closing arguments. And is the state ready to proceed?
We are, Your Honor.
All right. Mr. Stroller.
Yes, Your Honor, so ready.
All right, then let's bring the jurors on in.
Jurors entering the courtroom.
Okay. All right. Welcome back, ladies and gentlemen. You can have a seat. Thank you very much. Thank you again yesterday for your time and attention, and the same throughout the course of this last week and a half. As you heard yesterday, both the state and the defense have rested their cases, so the attorneys now will be able to present final arguments to you. Please remember, though, what the attorneys say is not evidence. Evidence has come before you in the form of witness testimony, documents, photographs, clothing items, things of that nature. But you should listen very carefully to their arguments. The arguments are intended to aid you in understanding the case and the law that I will instruct you on. Each side basically will have about the same amount of time to address you. However, under our rules, the state is allowed to divide their time. So first, we will hear from the state, and then I expect we'll probably take a break for lunch. After lunch, then we'll hear from Mr. Strolla on behalf of the defendant, Mr. Dunn, and then after that, we will have a final argument, rebuttal argument, if you will, from the state. So that's how that will work. And then, of course, as I mentioned to you, I think yesterday, at the conclusion of the arguments by the attorneys, I will then read the instructions on the law that's applicable in this particular case to you, and then at that time you'll be allowed to retire to your jury room to deliberate a verdict. So with that, we can begin, and we'll hear first from the state, and Ms. Wolfson.
May it please the court?
Yes, ma'am.
Let me be very clear. On November 23rd, 2012, when this defendant shot and killed Jordan Davis, there was no gun in that Durango. There was no stick, there was no bat, there was no lead pipe, there was no gun. What was in that Durango were 4 teenage boys. 19-year-old Tommy Storm, 17-year-old Tevin Thompson, 17-year-old Leland Brunson, and 17-year-old Jordan Davis. 4 teenage boys who had their whole lives ahead of them. A whole world to look forward to. 4 teenage boys who on the day after Thanksgiving were doing what any other teenage boys would do. Riding around, listening to music, going to the town center, trying to meet girls. What any normal teenagers would do. Stopping at the gate gas station, Tommy Storms ran inside that store to go get gum and cigarettes, never knowing that this defendant's actions were about to take place and about to take the life of their friend Jordan Davis. 5'11", less than 145 pounds. Jordan Davis didn't stand a chance. Sitting in the back of that SUV, being frantically pulled by his best friend Leland Brunson, as this defendant fired round after round after round into that car. 6.25 pounds of trigger pull each time he made the conscious decision to pull the trigger. Systematically and methodically shooting into that SUV. Two worlds collided on November 23rd, 2012. Rhonda Rauer and Tommy Storms, both inside the store, moments before their lives would be forever changed. Each running inside on their own missions, not knowing that this defendant was outside the store, ensuring that their lives would be forever linked by his rage and his actions that night. 10 rounds, 9 of them hitting that car. 9 of them hitting this defendant's target. It was target practice for the defendant. They had nowhere to go and nowhere to hide. 3 of those shots found exactly the target the defendant was aiming for first. Jordan Davis in that rear passenger seat. So close to where this defendant was, the defendant couldn't get out of his car. Tevin Thompson testified he couldn't have gotten out of that car. And even if Jordan Davis could have opened that door, I guarantee you he wasn't going to be able to just open it and jump out of the car. First shot, well, maybe not in this order, one shot though, entering the right side of Jordan Davis. Cutting through his liver, his lung, his aorta, until it found his final resting place up near his left armpit. A trajectory that is only consistent with his body being almost horizontal. A second shot, coming in through the back rear, his right back inner thigh, and then coming out of his right inner thigh. And then the third shot, coming into his left groin, only to lodge into his left hip. 3 shots that Dr. Simons testified would only happen if Jordan Davis was in a particular position. But the defendant, he didn't stop there. He didn't just hit Jordan Davis and decide he'd stop. He kept on shooting. 4 more rounds as Tommy Storms was driving to save their lives. As the car was backing up, 4 more rounds into Tevin Thompson's, 3 rounds hit Tevin Thompson's door, and a 4th missed. And then, a pause. As the defendant decides he needs to readjust himself and open that door, crouch down with his 2-handed grip, and keep shooting. Round after round after round, as that SUV left the scene and drove to safety. Now, I anticipate at the end of this trial, once closing arguments are done, Judge Healy will instruct you on what the law is and how you are to go about applying the law in your deliberations in this case. And I anticipate that 2 things he'll first tell you are that the state must prove date and venue. Neither one of those are at issue in this case. The murder and the attempted murders happened on November 23rd, 2012, and the venue was, of course, here in Jacksonville, Duval County. But there are then 2 other questions that you as members of the jury must ask yourself. The first being, was the crime alleged committed? And the second being, was the defendant the person who committed the crime? And these are both questions that every jury must answer in doing their deliberations. Now, as stated at the beginning of this case, the defendant is charged with 5 counts. First-degree murder, 3 counts of attempted murder for each of the 3 boys in that car, and then shooting or throwing deadly missiles. Now, Judge Healy will also instruct you on beyond a reasonable doubt. And I anticipate he will read to you a very lengthy instruction on what beyond a reasonable doubt means. But what I want to make you all aware of is that beyond a reasonable doubt only applies to the elements of each crime charged. And reasonable doubt is oftentimes better understood by what it is not. Reasonable doubt is not a mere doubt. It is not a speculative doubt. It is not a possible doubt. It is not an imaginary doubt. It is not a forced doubt. Murder in the first degree. In order for the state to prove that Michael Dunn committed first-degree murder, there are three elements the state must prove. One, that Jordan Davis is dead. Two, that the death was caused by the criminal acts of Michael Dunn. And three, there was a premeditated killing of Jordan Davis. Now, there's a number of different definitions that go with this crime, so we'll go through them one by one. An act includes a series of related actions arising from, and performed pursuant to a single design or purpose. Now, as mentioned in jury selection, this doesn't mean that this defendant needed to have some elaborate plan to kill Jordan Davis. It doesn't mean that he needed to have a blueprint for how he was going to do it. What it means is that this defendant had a series of actions that together were the criminal act that killed Jordan Davis. This defendant told you what actions he took. He sat up on the stand yesterday and gave you, I think it was probably 10 steps he took prior to firing those shots that killed Jordan Davis. Now, the definition of killing with premeditation. Killing after consciously deciding to do so. The decision must be present in the defendant's mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. Now, once again, there's no certain amount of time that is required for the defendant to form that intent. The law requires sufficient time. It doesn't say significant, just sufficient. And consciously deciding to kill doesn't mean that someone has to wake up that morning and decide, I think I'll go kill like so-and-so. It doesn't mean that they needed to have this plan, like I stated earlier, just that before this defendant pulled that trigger, he knew what he was going to do. He had every intention of killing Jordan Davis. Now, the sufficient time for reflection. The period of time must be long enough to allow that reflection by the defendant. And the premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused, Michael Dunn, convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. The defendant's own actions, along with everything surrounding that killing, that's what you as members of the jury can use in determining whether or not what this defendant did on November 23rd, 2012 was premeditated murder. Now, the judge will also instruct you on what are called lesser included offenses. And for counts 1 through 4, there are lesser included offenses. So, for example, murder in the first degree is the premeditated murder. The next lesser included offense to that is second degree murder. And one way to look at the difference between these is that murder in the first degree is the intent to kill a human being. Murder in the second degree, however, is not caring if you kill a human. It's doing an act that could reasonably lead to the death of someone, but not actually caring whether or not you kill them. So the elements for second degree murder, and these of course are what reasonable doubt applies to. Jordan Davis is dead. The death was caused by the criminal acts of Michael David Dunn, and there was an unlawful killing of Jordan Davis by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. And I know that's a lot of words, and so of course there's definitions. Imminently dangerous and demonstrating a depraved mind. If it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or cause serious bodily injury to another, and this act is done from ill will, hatred, spite, evil intent, and is of such a nature that the act itself indicates an indifference to human life. Now, it's not necessary for second-degree murder for the state to prove the defendant intended to kill that individual. But second-degree murder, for example, would be like a one-stab wound. An act that obviously is imminently dangerous to that other person, but you may not have intended to kill that particular person. But it's an act that a person of ordinary judgment realizes could lead to that person's death. Sending 9 bullets into a car full of unarmed teenagers, that is second-degree murder, no doubt. It is reasonably certain that an occupant of that vehicle could suffer death or grave bodily harm. That act itself shows an indifference to human life. However, in this case, we don't have just second-degree murder. We have first-degree murder because of his intent to kill. And finally, the judge will also instruct you on the third lesser-included offense for murder in the first degree, and that is the offense of manslaughter. And manslaughter is just that Jordan Davis is dead and that the defendant intentionally committed an act or acts that caused the death of Jordan Davis. Now, manslaughter, while the act itself is intentional, it doesn't have to reasonably lead to death or great bodily harm. It would be, for example, like pushing someone and they fell over and hit their head and then that person died. That is not what we have here. As I stated earlier about second-degree murder, this defendant, when he took that gun out and started shooting at point-blank range, he knew what he was doing. He knew that what he was doing could cause death or great bodily harm to those boys. Now, Judge Healy will also instruct you at the end that in regards to these lesser-included offenses, your verdict must be for the highest charge the state has proven beyond a reasonable doubt. How have we proven premeditation? How is this defendant guilty of what he is charged with? Well, he had some anger prior to the confrontation. I hate that thug music. That's what Rhonda Rower stated from the stand when she testified on Saturday. Although this defendant said, I wouldn't use the term thug music, I call it rat crap. This defendant, when he pulled up next to that SUV, his blood started to boil. He didn't like the music that was coming out of the car next to him. He got angrier and angrier as that music irritated him. In fact, it bothered him so much that he took it upon himself to interject himself into their lives, rolling down his window and asking them to turn it down. And then the boys did, but when Jordan Davis decided he didn't need to listen to him and he wanted to turn it back up, this defendant went crazy. He got angry at the fact that a 17-year-old kid decided not to listen to him. The defendant, when he pulled out his gun, he shot to kill. 10 shots, 9 of them hitting the car. And he was shooting at point-blank range. As I stated earlier, the cars were so close, he couldn't get out of the car. Tevin Thompson couldn't get out of the car. And Jordan Davis couldn't get out of the car. And he had a big gun, a 9mm gun. Those are big bullets.
Your Honor, I'm going to object to mischaracterization of the evidence. The witness testified as medium.
It's overruled.
And I believe they say medium to large. But refer with your memory from the evidence and the testimony that came out during trial. This defendant not only had a big gun and was shooting at point blank range, but he was shooting at their body mass, where he knew their center mass would be. He wasn't shooting at the tires. He wasn't shooting at the door rails. He was shooting in the middle of the doors where Tevin Thompson, Leland Brunson, Jordan Davis, and Tommy Storns were ducking, trying to save their lives. Detective Kipple testified that those 3 shots in that front door, Tevin Thompson's door, if there hadn't been that extra layer of metal, those would have gone right through as well. Six pounds of trigger pull each time he fires that gun, making a conscious decision each time to exert that amount of force, discharging a bullet, sending it into that car. Round after round after round. And the location of the bullet holes, as I just stated, the fact that they're all those first 6, the center mass. He wasn't shooting just to scare them off. He was shooting to kill. He was shooting for his targets. And aiming at Jordan Davis. This defendant told you himself yesterday his intention was for Jordan Davis. He even told you that next 3 set of shots to hit Tevin's door, those were for Jordan Davis. That is premeditation. Knowing when he pulled that gun up, he had it ready to go. He didn't pull a gun out just to brandish it, try to back him off. He pulled it out and immediately started firing. And of course, his own admissions. He had every intention of killing Jordan Davis. He intentionally engaged those boys, and he's the one who escalated that situation. He's the one who knew when he got into that argument with them that he had a loaded firearm in his glove box. He claimed he was trying to de-escalate the situation. But I'm not quite sure how you de-escalate a situation when you're the one who rolls down the window, rolls it back up, and then rolls it down again to keep having a confrontation with the car next to you. I don't consider that de-escalation. I don't consider pulling out a firearm from your glove box, pulling it out of the holster, rocking around, and then immediately shooting into a car de-escalation. Their car. 3 rounds into Jordan Davis's car. The first 3 shots that this defendant fires. He told you himself he took aim and then he fired. He didn't use crosshairs, but he still had both of his hands on that gun, aiming at his target. 3 shots so tight in the way they hit that car. This defendant wasn't outraged. He had steady hands when he was shooting at Jordan's door. The car at the scene that night. Ladies and gentlemen, Jordan Davis was not outside of his car. He wasn't standing there with 2 feet on the ground and his body maybe inside. I think the defendant, when asked by Mr. Guy yesterday, said, "Oh, you're splitting hairs," when asking where Jordan was. There's 2 circles on the door showing where the bullets came in. The bullets popped out that plastic that's now lying on the seat of the Durango. As Detective Kipple testified to, fit like a jigsaw puzzle. There is no way this plastic would have been where it was if Jordan Davis was shot outside that car. There is no way in those seconds. The first round of shots, and you'll have the surveillance video back so you can listen to it. First round of shots happened within like a second and a half. And a second later, there's the next 4 sets of shots. And in that time, Tommy Storms has thrown the car into reverse, trying to get out of there. That is not enough time for Jordan Davis, if he's outside the car, to manage to get in the car, shut the door behind him with a bullet through his aorta, have this plastic somehow land back on the back seat, and then the car to back up so that the second set of shots can hit Tevin's door. That is not what happened. And this is physical evidence of that. The dowel rods coming through the door. And once again, you can see the bits of plastic better in this particular photo. But it's important in the other one because in the other one, that was at the scene. Nobody had touched the car at that point in time except to pull Jordan Davis out of the back seat. This shows it even better. That piece of plastic from the door handle got blown into the back seat from the bullets of this defendant's gun. All 3 boys testified Jordan Davis was sitting in that car. Detective Kipple's testimony. That plastic fit like a jigsaw puzzle. And then Dr. Simon's testimony. The medical examiner who examined Jordan Davis that night and the following morning. The first penetrating gunshot wound. As she stated, it entered his lower right side, had a diagonal path, and ended in his upper left armpit. The only way for Jordan Davis to get shot like that would be if his body was at an angle, or as she said, the shooter was on the ground. And there's no evidence this defendant was ever on the ground below Jordan Davis shooting up at him. The only evidence there is that makes you better understand this shot is the way Jordan was positioned in that car. Entering the right side, the liver, right lung, and aorta, and Dr. Simons drew an excellent diagram during her testimony, and then stopping in the left chest wall. And then the second shot, the second penetrating gunshot, entering his left groin, lodging in his left hip, once again having that same trajectory as the one that ultimately killed him. And finally, the perforating gunshot wound, entering the back right thigh, and the exit wound inside of his leg. Now, she testified. And she used this to better explain to you all just how those bullets entered Jordan Davis's body. She said there was no way that Jordan Davis would have been standing up. He had to have been at an angle that allowed for his body to be shot in the manner that this defendant shot him. And the only logical way for that to have happened is if he was shot when Leland Brunson was frantically pulling his best friend away from this defendant, away from the gun that ultimately killed him. And Mr. Strolla tried to give Dr. Simon some hypotheticals. Well, what if he was standing outside? Can you see me with my legs up? All these sorts of things. But Dr. Simon said Jordan was not outside of that car. He was sitting in that seat, bent over, trying to escape from his ultimate killer. And what about if Jordan was jumping back into the car? As I stated before, that doesn't make sense. The plastic bits in that door wouldn't have been where the evidence technician found them. And when the boys pulled back and came back after realizing that Jordan had been hit, what did Officer Holmes tell you all? He's the first officer to open that door. And he described in great detail the horrific scene he saw. Leland Brunson sitting there, holding Jordan's head, Jordan Davis's shoulder on his hip. And then when Officer Holmes came around to Jordan's side of the car and opened that door, his rear end was lifted up. Consistent with Dr. Simon's testimony. Consistent with the bullet trajectories. Consistent with how the boys described Jordan Davis before he was shot. Premeditation. 3 more shots into Tevin Thompson's door. Total of 6. Just on the passenger side alone. 3 more as the boys are driving off, trying to save their lives. This defendant told you himself the car had already left the scene. He told you he never saw a gun as they were pulling off. But yet he continued to fire round after round after round. He told you yesterday he intended to shoot any of them when they were driving off. He didn't care who it was. This bullet so close it almost hit Tommy Storm's head. Coming in from the back. That is not something a reasonably prudent person would do. That bullet came in whizzing by Tommy Storm's head as he was doing nothing more than driving away from someone who was trying to kill them. And if Jordan Davis hadn't already been hit, I guarantee you this bullet would have gotten him. Came in right over the rear passenger seat. Now, of course, you also must consider time for reflection in determining whether or not what this defendant did was premeditated murder. And as I stated, the law doesn't require a significant amount of time. It's just sufficient time for the defendant to reflect on his intent to kill and his actions. Every step in this process was under his control. Every action he took was a conscious decision that he made to escalate the situation and ultimately kill Jordan Davis. Rolling his window down to start the confrontation. And that was in a matter of seconds. Rhonda Brower had just gotten out of the car to go into the gas station. She was only inside that gas station for 1 minute and 36 seconds before this defendant fired that first shot. And I say only, but when you think about it, 1 minute and 36 seconds is an extremely long time. It's enough time for this defendant to start the argument, to then re-engage when he rolls his window back down, to ask Jordan Davis, "Are you talking to me?" And he did not like Jordan Davis's response. "Yeah, I'm talking to you." This defendant was disrespected by a 17-year-old teenager. And he lost it. He wasn't happy with Jordan Davis's attitude. What was his response? "You're not going to talk to me that way." So Steve Smith testified to that. Completely independent witness. Steve Smith didn't hear the defendant say, "You're not going to kill me." He heard loud and clear, "You're not going to talk to me that way." And that is what made Steve Smith turn his head and look. Not whatever was going on from the red SUV. He didn't hear any of that. He didn't hear anything coming from the red SUV. The only person who hears the defendant say, "You're not going to kill me," is the defendant himself. He's the only one who said he ever said that. The defendant isn't yelling, "He's got a gun, put the gun down, don't shoot me." He's not yelling any of that. All he's saying, "You're not going to talk to me like that." And then what does he do? His actual actions. He reaches into the glove box, pulls out the gun. It's in a holster, so he has to use two hands to get the gun out of the holster. He then takes the safety off. This is all with whatever's going on behind him, the threats he's hearing. Takes the safety off, brings it up, wraps around, which, by the way, is exactly what Leland Brunson said happened. He even demonstrated for you. He wrapped around, turns the gun around with both hands, positions himself so he's a better shot at Jordan Davis, and then he starts shooting. I think it's about 10 steps he took. 10 separate steps, ending with that 6.25-pound trigger pull. He doesn't just shoot once, doesn't shoot twice, not 3 times. He just shoots over and over and over again. This defendant had sufficient time to reflect on his actions. According to the defendant, he says Jordan Davis is out of the car, but yet he can only see his feet. He's not sure where Jordan Davis is. Doesn't see the gun at that point in time. That, by the way, nobody else sees. He knew where Jordan Davis was, and he knew he wasn't armed. But this defendant didn't care. He had already decided what he was going to do. As he testified yesterday, he's owned that gun since, what, the 90s? He goes shooting all the time. Has a carrying concealed weapons license. You only pull your gun out if you're going to use it. He didn't pull it out and just show it off. He pulled it out, took aim, and fired. Finally, his behavior after the fact shows what his intent was at the time. The conduct of the accused. He flees. I anticipate Mr. Stroller will get up here, as he said in opening. He didn't actually flee. He has a pilot's license. You know, he didn't leave. Ladies and gentlemen, he fled. He left the scene where he shot and killed a 17-year-old. I don't care if it's a mile, 2 miles, 3 miles. He left the scene of that gate station. And it was at his insistence. Everything else he blames Rhonda Rauer for, but this particular one, he can't blame her for. She comes out of that gas station, not knowing what this defendant had just done. Get in the car, get in the car. And she does. And they drive 3 miles away, roughly 3 miles away, to the hotel room. This defendant shouldn't get credit for the fact that he stayed in the state of Florida, stayed in Jacksonville that night. He didn't use his pilot's license. He fled the scene and notified no one of what he had just done. And while this defendant is driving off, Tommy Storms, Leland Brunson, Tevin Thompson are on their way back to the gas station with their dead friend in their car. If they truly had a shotgun, wouldn't they be the ones who left the scene? They had nothing to hide. Tommy Storms was on probation. He knew he was in violation of his probation. He came back to the scene. The only person who left is this defendant, because he knew what he had done was wrong. He eats. They go back and order a pizza. To settle Rhonda Rauer's stomach? And it's her fault. According to the defendant, they ordered the pizza. And of course, they went back to walk his dog. Those are not the actions of somebody who shot in self-defense. Those are the actions of somebody who intended to kill someone. And then realizing what he did was wrong. And when he got back to the hotel to walk his dog, he didn't take his gun with him. The defendant testified yesterday. When he got to the hotel, he looked out that window. Every car looks like a red SUV. He was in a waking nightmare, I think is the term he used. If you're so terrified, why is your gun in the glove box? Oh, and by the way, when he left the scene of the gas station, he puts the gun in the glove box and then drives off as if nothing happened. He didn't hold on to it thinking, what if this SUV comes back? And he makes a drink, a stiff one, because he was being so stoic and trying to calm the nerves of Rhonda Rauer. Rhonda Rauer didn't know that this defendant had just killed a 17-year-old. And when the defendant learned at 1 a.m. that one of the people in that car had died, what did he do? He didn't wake up Rhonda Rauer, the love of his life, to tell her, oh my gosh, I killed somebody. He didn't go call 911 and say, listen, I need to tell you what happened. He didn't care. He let Rhonda sleep right through the night. And he himself then went to bed at 5 a.m. Those are not actions of somebody acting in self-defense. He makes no calls to 911. None. Rhonda Rauer makes no calls to 911. And that's for the hours they're in Jacksonville, overnight, on their 2.5-hour drive home, that according to the defendant went by in a flash. And they had just suffered and gone through the most traumatic event of their lives. Now, the defendant testified that he was notifying his neighbor, who's a federal agent, or something like that, who works at the Department of Agriculture. But Rhonda Rower testified yesterday. Michael Dunn didn't call him. The neighbor called. There was no discussion on the phone on the way down to Brevard of Michael Dunn going next door and telling him what happened. This defendant didn't tell anyone because he thought he had gotten away with murder. He had no idea that Sean Atkins, a now 20-something time convicted felon who came in here and testified, he had no idea that Sean Atkins practiced common courtesy. Sean Atkins saw what happened, and he had the foresight to take down this defendant's tag number, walk into that gas station, and give it to Lillian Christensen. This defendant had no knowledge of that. For all he knew, nobody knew he was the shooter. He had no reason to hide his car when he got to the hotel. He had no reason to hide it when he got home. Oh, and he makes no mention of a firearm to Rhonda Rower. Wouldn't that be the first thing you tell the love of your life when she gets back in that car with you? I shot someone, but they had a gun pointed at me. She testified yesterday, he made no mention of that. Never. The first time he mentioned it to her is in a letter, December 5th, 2012. And this letter's in evidence when he says, he mentioned in passing that I had made no mention of a gun to you, based on your testimony to the prosecutors. He asked what I had told you, and I then realized that we hadn't really discussed what had happened, as we were more concerned with whether or not anyone was hurt. This defendant was not concerned whether or not anyone was hurt. When he found out he killed someone, he did nothing. And the only time he mentions to Rhonda Rower, oh, by the way, I forgot to tell you there was a gun involved, is when he learns that she has talked to police and the prosecutor. As Mr. Stroll pointed out, that was me. That's when he realizes, whoops, never told you about that. These are his actions because what he did was premeditated. It was not self-defense. Now I'll explain to you briefly what self-defense instructions are. But let me be very clear again. There was no gun in the Durango. The only person who says there was is that defendant. His statements are uncorroborated. And he's not even consistent with what he saw. But you'll be instructed on the justifiable use of deadly force. And you'll be instructed that the use of deadly force is justifiable if Michael Dunn reasonably believes that the force is necessary to prevent imminent death or great bodily harm to himself while resisting another's attempt to murder him, another's any attempt to commit aggravated assault, aggravated battery, or attempted murder upon him, and any attempt to commit aggravated assault, aggravated battery, or attempted murder upon or in any vehicle occupied by him. This defendant was not justified. He did not have a reasonable belief that Jordan Davis was about to kill him or cause great bodily harm to him. Jordan Davis was inside his own car. And if he got out at all, he certainly didn't come close to this defendant. The cars were too close for him to do that. Now, you'll also be instructed that the law of self-defense goes on to say that a person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or another, or the imminent commission of aggravated assault, aggravated battery, attempted murder, or murder against himself or another. And the self-defense instruction continues and says that in deciding whether the defendant was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time that force was used. Now, the danger facing the defendant need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person, under the same circumstances, would have believed that the danger could be avoided only through the use of that deadly force. Based upon appearances, the defendant must have actually believed that the danger was real. It doesn't just let you assume something might happen. Was this defendant's behavior that of a cautious and reasonably prudent person? I think not. The number of shots he fired, the pattern of those shots in that car. If there was a gun in that SUV, wouldn't they have shot first once they saw him reaching for his gun? If Jordan Davis had a shotgun in his lap, and they see the defendant going for his pistol, wouldn't that make sense? There were no shots ever fired at this defendant. And from the surveillance tape, his series of shots was about 10 seconds. That's a long time in the scheme of things. There was no gun or weapon ever found. And that wasn't because of shoddy police work. That was because there wasn't one. The boys didn't have a gun. They didn't have a stick. This defendant, in firing his shots, even missed one of the rounds. He was open firing in an open, crowded parking lot. And then the defendant, as I said earlier, when he gets Rhonda Rower back in the car, if he's so fearful, why on earth does he put his gun back in his glove box? As he told you all, he thought they were coming back to get him again. Is that an act of someone who's truly in fear? That he puts his gun back? He thought they were a car full of gangsters. He thought there were more of them. He thought every car after that was a red SUV. And once again, his behavior after the shooting. And as I stated, that the danger could only be avoided through force. The defendant's the one who rolled his window back down. He's the one who re-engaged these boys. He's the one who's brandishing his gun. The fear that he had of that shotgun wasn't reasonable because there wasn't a shotgun. Michael Dunn does not get to just assume Jordan Davis had a gun and assume that he was pointing it at him. What did he tell you from the stand? He said he thought he saw a barrel come up out of Jordan's window. From my recollection, I don't remember him ever saying that gun was pointed directly at him. and that he heard it slam against the door? Michael Dunn couldn't even see what Jordan Davis was reaching for, if he in fact was reaching for anything, because the car door is in the way. He couldn't see through that car door. And then, according to his testimony, Jordan opens that back door. And what did Michael Dunn tell you? He told you that he could see Jordan's head over the door frame. He could see his feet on the ground. But then at some point, he didn't know where Jordan Davis went. He never saw the shotgun again. That's a fact. The only time he claims he saw one was when it was sticking up out of that window. This defendant didn't know what Jordan Davis was going to do when he stepped out of that car. He was assuming. And self-defense does not let you assume. Nine shots into that car. The defendant left the scene unscathed. Jordan Davis had been out of that back seat when he was shot. Car doors don't close by themselves when they're reversing. Somebody who's been shot 3 times with a bullet through all of your organs doesn't close the door behind them and get in the car. That back door would have scratched the side of Michael Dunn's car. For a fact. They were parked so close, and when Tommy Sorens pulled out, he pulled right around behind Michael Dunn's car. There is no way Jordan Davis's door closed on its own or by Jordan Davis. And once again, an example of why Jordan Davis was inside that car. The 3 shots to kill Jordan Davis. Was it really self-defense? Once again, there was no gun, so it's not. But if it were, which I anticipate is the argument the defense will be making, 10 rounds, 3 of which when the car is fleeing? And after this defendant repositioned himself. He was in such fear that he opened the door, and in his words, he actually got out of the car and walked down, I guess, to the middle of the street and kept shooting. That's what one of his letters says. The SUV pulled forward and I got out of my car and ran a few feet behind my car. I started firing on them as they fled, aiming specifically for the center line of the vehicle. I stopped shooting when they were too far away for me to hit them accurately. He didn't take cover when, in his words, the car that he was in such fear of is driving off and possibly going to be shooting back. He testified he never saw a gun as that car drove away. He never heard any threats as the car drove away. He never was shot at. This defendant suffered no injuries. And then he left the scene, not calling 911. If he was in such fear of a car full of gangsters, wouldn't he call the police to at least say, hey, there's a red SUV out there and they have a gun in it. You might want to go find them. They're dangerous. He doesn't call anyone. And no mention of a weapon to Rhonda Rower. None. And Mr. Stroll tried to ask her, you're under a lot of strain. and stress with the situation. Wouldn't that be the first words out of her mouth if her fiance told her, oh, the boys had a gun? Wouldn't that be the bit that she probably remembers the most from what he told her? She was very adamant on that stand. Although probably unwilling to come in here, she did. Once you got in the car and headed to the hotel, did the defendant ever tell you about a firearm? Nope. Did he ever tell you about a weapon? Nope. Once you were at the hotel, for what, 12 hours? Did the defendant ever tell you about a firearm from the SUV? Nope. Did he ever tell you about a weapon of any kind? No. And then 2.5-hour drive down to their home in Brevard, knowing somebody had died. Did the defendant ever tell you about a firearm? No. Did he ever tell you about any weapon he saw? No. Now, the judge will also instruct you on the other charges that this defendant is charged with. Attempted murder in the first degree, 1 count for each of the boys who survived. 1 count for Tevin Thompson, 1 count for Leland Brunson, and 1 count for Tommy Storns.
Your Honor, if I can object and just approach Your Honor.
Yes, sir.
May I continue, Judge?
Yes, ma'am, I'm sorry.
Now, His Honor, Judge Healy will also instruct you on attempted murder in the first degree. And as I stated and as read to you before this trial started, the defendant is indicted on 5 counts. The first one, murder in the first degree. The second 3, attempted murder in the first degree. Now, in order to prove attempted murder in the first degree, the state must prove the defendant did some act intended to cause the death of Tevin Thompson, Leland Brunson, or Tommy Storns. And the defendant acted with a premeditated design to kill. That the act would have resulted in the death of Tevin Thompson, Leland Brunson, or Tommy Storns if that act had actually been completed. These final 3 shots, this defendant intended to kill any and all of them. He didn't care who he was shooting at. As long as he was hitting that SUV, he kept shooting. The SUV had already left. The threat that he perceived was already gone. And yet, the defendant took it upon himself to get out of his car, holding his gun with two hands, crouching down, the position Sean Atkins took. It's how this defendant described it. And then shooting round after round after round as that SUV drove away. And the defendant admitted, despite, he kept referring to it as, I think tunnel vision is what he had, kept referring to yesterday on the stand, that he just had tunnel vision, just saw one red door, and he kept shooting. But he also testified that he saw that SUV pull forward. He knew it was leaving the scene, and he shot at the backs of unarmed teenagers. That is attempted murder in the first degree. He said yesterday too, I think he said, well, there was one gun for them, so he was just shooting at all of them. But as I stated earlier, there was no gun in that Durango. The defendant knew no one had fired back at him when he fired these 3 shots. He knew that. There's a couple second pause between the first 2 volleys of shots and this third one. And the defendant told you, though, at this point in time, he was scared of blind fire. Something, once again, that was only in his imagination, just like the shotgun. Now, His Honor will also instruct you on the lesser included of attempted first-degree murder. And attempted murder in the second degree would then be the first lesser included of that charge. And in order to prove attempted murder in the second degree, the state must prove the defendant intentionally committed an act which would have resulted in the death of Tevin Thompson, Leland Brunson, or Tommy Storms. The state must also prove that that act was imminently dangerous to another in demonstrating a depraved mind without regard for human life. And those phrases, the imminently dangerous for another and demonstrating the depraved mind without regard to human life, those are the same definitions from premeditated first-degree murder and second-degree murder. And finally, the judge will also instruct you on attempted manslaughter by act. That Michael Dunn intentionally committed an act which would have resulted in the death of Tevin Thompson, Leland Brunson, or Tommy Storms. And that except that someone prevented Michael Dunn from killing them, or he failed to do so. But as I stated before, what this defendant did on November 23rd, 2012, rose to the level of premeditation. That is why he is sitting here indicted on first-degree murder charges and attempted murder in the first degree. And finally, the 5th count, shooting or throwing deadly missiles. That Michael Dunn shot a firearm, that he did so at or into a vehicle of any kind that was being used or occupied, and that the act was done wantonly and maliciously. Now, I've defined both wantonly and maliciously for you, and it's something that Judge Healy will obviously instruct you on at the end of this trial as well. Obviously, what this defendant did was intentional. It was a conscious decision with a reckless indifference to what those consequences would have been. Now, His Honor will also instruct you on how you can go about weighing the evidence. How are you to decipher the testimony you heard? What tools can you use? And he'll read to you what are called weighing the evidence instructions. Did the witness seem to have an opportunity to see and know the things about which that witness testified to? And as Mr. Guy pointed out in opening statements, the people you heard from are real people. The civilians who were at the gas station. They told you what they remembered from their points of view that night. Now, did everything jive? Was everything matched up like a perfect puzzle piece? Of course not. This is real life. This isn't television. It's not a crime show. Those people came in here over the past few days and told you all what they remembered seeing. Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the defendant's questions? In reference to that last one, what about this defendant's own statements? What about his testimony in court? He heard loud thumping music when they pulled in. He saw two young men with menacing expressions, Jordan Davis and Leland Brunson. But yet he told detectives, I don't know how many kids were in that car. He used the word kids the day after he shot into that SUV. It was only 6 months later, I think, when he wrote his statement that he writes, I glanced back and saw the rear windows were down and the back seat was occupied by two very menacing looking black men.
Your Honor, you can object to this approach.
Yes, sir.
Menacing expressions on two young men versus I don't know how many kids. His own testimony yesterday when he said, Jordan Davis made his intentions very clear. Followed by, I didn't know what his intentions were at that point. Inconsistencies in this defendant's own statements yesterday. He stepped out. He told you from that stand, Jordan Davis stepped out. His 2 feet were on the ground. His whole body was out of the car. What did he tell detectives? He opens the door. Those are two very different facts. Inconsistencies in this defendant's statement about what happened. And here's the other one. Heard loud thumping music. And what does he tell the detectives in that interview? She gets out of the car, and then the music starts. Rhonda Rower told you herself from that stand, she heard that music. She told you this defendant told her, oh, I hate that thug music. And the defendant tried to clarify, well, I think what I actually meant was the bass hadn't started yet. Steve Smith heard that bass when he pulled up. He practiced common courtesy. He moved his car. Then went inside, minded his own business, made a joke about the music with the cashier, and then walked outside and watched this defendant murder Jordan Davis. What did he say yesterday? Probably had 3 to 4 drinks. What Rhonda Rauer said was correct. I probably had 3 to 4 drinks. What did he tell the detectives? I had a toast, something to toast with, and a rum and coke. That's what he said the very next day, when his memory probably should have been, I guess, the clearest and the freshest. More inconsistencies of the defendant's statements. He said from that stand he heard Jordan Davis saying something, something cracker, and that's what started getting this defendant riled up. He never told this to the detectives in his interview. I should effing kill that mother effer. That's what the defendant testified to yesterday as Jordan Davis having said. That's what's in his letter, his account of what happened that he drafted 6 months after getting arrested. Never told that to the detectives. Jordan Davis slammed whatever it was against the door. He didn't even say shotgun. Whatever it was, he slammed it against the door. Do you think he told that to the detectives? Never did. This shit is going down now. That's the statement this defendant says is what set him off. That's when this defendant decided, I need to take matters into my own hand, pull out my gun, pull it out of the holster, take the safety off, chamber around, turn and shoot. That's the phrase this defendant said made him fear for his life. Did he tell the detectives that? Nope. He didn't. He failed to tell them the phrase that he said set him off. How does he fail to tell the detectives the very next day what Jordan Davis was saying? Because that's not what was said. You're not going to kill me, you son of a bitch. That's what the defendant testified to yesterday, as having said to Jordan Davis. That's what's in his written letter. The last words out of his mouth as he's fighting for his life. Did he tell the detectives that? Nope. He never did. Because what he actually said was, "You're not going to talk to me that way." The exact phrase that Steve Smith heard. And the defendant has even more inconsistencies. He told you all from that witness stand, why didn't it notify any law enforcement till the next day? But then on my drive home, I called my neighbor, Department of Agriculture agent, and I told him, I have something important to talk to you about. Can I come over when I get home? His own phone records show, though, that the neighbor actually called him. And then Rhonda Rauer got on the stand and said, "Oh, I heard that whole conversation. Ken Lescalay was on speakerphone." The defendant never mentioned needing to go talk to him. He never mentioned, I have something important to talk to you about. He never mentioned, I shot and killed somebody in self-defense and I don't know what to do. All the defendant said was, we're not going to St. Augustine anymore. Rhonda doesn't feel well. That he used the term rap crap instead of, ugh, I hate that thug music. The defendant testified when I got to the hotel, I was going to take my gun inside with me out of fear of the red SUV coming back to attack me. But Rhonda, she's the one who told me not to take it with me. What did Rhonda Rauer say yesterday when asked that specific question? She doesn't remember ever saying that. She never saw that gun again. This defendant was asked multiple times on the witness stand. You told Rhonda Rauer, the love of your life, your fiance, that you saw a gun that night. Yes. That was the defendant's testimony. I did. He said he told her more than once. Based on this defendant's own statements in that letter that you all have in evidence, he realized back in December of 2012, he had never told Rhonda about the weapon. How did this defendant, who stressed to you all from that stand that his concern and his focus was on his fiance who was so distraught, how does that fact slip his mind? A fact that probably would have eased her mind a little bit. How did this defendant forget to tell her, by the way, I saw the barrel of a shotgun? It didn't happen. There was no gun. Mr. Strolla spent a large majority of this trial in his opening statements picking apart every single witness, criticizing everything they did, including Andrew Williams, who was a bystander who came and tried to perform CPR on Jordan Davis. Everybody who came in here and testified told you what they saw and what they remember happening. This is not a conspiracy between Tevin Thompson, Leland Brunson, Tommy Storms, the civilians at the gas station, Jacksonville Sheriff's Office, the evidence technicians, the medical examiner, and his own fiance. What about the 911 callers? The siblings. They called 911 immediately that night and told those operators what they saw. Did they use the word stash? Yes. Did they use the word throwing something from the vehicle? No. Those siblings testified to how far that SUV went. And if you'll remember, it was right around the same place that all the boys said the car stopped. They testified they saw the Tommy Storms, Tevin Thompson get out of the car. This is a car full of teenagers that had just been shot at 10 times. They didn't know what had happened or the status of everyone in their car. And when they got out, they looked in the back seat and saw Jordan Davis dying on Leland Brunson's lap. They were gone for about 2 minutes. Sean Atkins came in here and testified. He saw the shooting. He demonstrated how this defendant was shooting. Got that tag number. And once the red SUV pulled out, he comes inside, and you can see him on the surveillance tape. He comes inside, gets with Lillian Christensen. They write down the tag number. Whether Lillian Christensen writes it down or Sean Atkins writes it down, it doesn't really matter. They got the tag and wrote it down. And by the time Sean Atkins walks back out that front door, the red SUV is back. That's what he testified to from that stand. Then you can look at the timing yourself and see just how long that SUV was gone. They were gone long enough to realize their friend was dying and then get back for help. They weren't out there behind the dumpsters throwing guns up over the roofs, throwing guns around behind the building, throwing guns in the bushes. They stopped, checked themselves, checked the car, realized Jordan needed help, and went back because they had seen that this defendant had already fled the scene. All these people are not out to get Michael Dunn. The only person who testified in here who knew him was Rhonda Rower. This wasn't the defendant's unluckiest day, where he's the only one who sees this gun, where the police couldn't find this gun. It didn't exist. Reasons the defendant is guilty of all the crimes he is charged with. You're not going to talk to me that way. He had enough. Jordan Davis had mouthed off to him. Nobody came in here denying that. Nobody denied that Jordan was talking back. But this defendant took it upon himself to silence Jordan Davis forever. Even people who have a right to self-defense do not have the right to take the life of a child when that self-defense is unreasonable. The defendant's actions to get his gun. 10 steps. Where part of the time his back easily could have been to this threat. All the steps I've listed over and over again. The way he shot his gun. The number of shots. 10. 3 while the car is fleeing. The actual pattern of shots. He wasn't shaking out of fear. He had steady hands when he hit Jordan's door 3 times. The only reason the rest of the shots are spread out is because Tommy Storms was driving for his life. 6.25 pounds for each trigger pull. 6.25 pounds. That's over 60 pounds of pressure he had to use and exert to get off 10 shots. That gun didn't fire itself. His mindset at the time, as indicated by his statement of superiority, you're not going to talk to me like that. And of course, his behavior after the fact, blaming lots of things on Rhonda Rower and their dog. It was more important to make sure the dog went out for a walk and to get the dog home than it was to notify police who were working nonstop trying to figure out what had happened. It was more important to go walk the dog. This defendant's own statements with the detective. What did you see? Was it a shotgun? Could it have been a stick? Could you have imagined it? Anything is possible. This defendant does not get to claim self-defense because anything is possible. He can't assume that Jordan Davis was a threat with a gun. Ladies and gentlemen, Michael Dunn has had his day in court. He has had his trial, and he has had his right to be judged by 12. Today is the day that you all, as members of the jury, can define what this defendant did on November 23rd, 2012. This defendant may have forever silenced Jordan Davis, but he cannot silence the truth. He cannot silence this jury from rendering a fair verdict. A verdict that speaks for the truth. A verdict that holds this defendant accountable for his actions that night. And that, ladies and gentlemen, is a verdict of guilty as charged.
Thank you very much, Ms. Wolfson. Ladies and gentlemen, we will take our lunch break now, and we will break until 1 o'clock. At that time, we will resume. Please do not discuss the case among yourselves or with anyone else. Please don't form any fixed opinions, as we are not yet concluded. As I've told you repeatedly, conclusion only comes after you've heard the rest of the arguments and the instructions on the law that I will give you. Enjoy your lunch, and we'll see you back in about an hour.